Everything you need to know about products and services that can improve your life. This is Experts on Call on CL 650.
And welcome back to 650 CIL's Talk About Strata. Kind of an appropriate song, really. I heard it through the grapevine because there's so much misinformation that passes between strata corporations and people in this industry, and that's the root of some of the issues that we have. One of the challenges that we have for strata corporations, Adrian, is that the strata often has difficulty with bylaw enforcement. Because we have an owner, for example, who is, take one of the emails that I had, that an owner has decided to bring a dog into the building. There's a bylaw that says no dogs. Sure, the strata corporation can fine an owner, but at some point that's not going to solve the problem. And that's the whole point of fines, is to try to remedy behavior. If that doesn't work, their options really are then get into court for a court application in Supreme Court for a decision. But then you have the problem where the person who's complaining about the dog might be in the minority, but the strata corporation needs a 3/4 vote to be able to make the Supreme Court application to enforce the bylaw, which strata corporations, when there's money and time and severity involved, frequently vote down.
Well, and that's the true issue in bylaw enforcement. So the Act contemplates fining an owner, and fining an owner is punitive. You hope that it will result in changed behavior. Some people just view it as a cost of doing business, or just simply ignore the issue. So if we really want to enforce the bylaw, we have to get a court order ordering the owner to comply with the bylaws. In order to get a court order, we need to go to BC Supreme Court. And in order to go to BC Supreme Court, I need a 3/4 vote of the owners to do that. And that usually involves money as well, because very few stratas are anxious to litigate on their own behalf, so they're going to need to retain legal counsel. So it's really a twofold resolution. One, with the owners authorizing the strata corporation to initiate legal action. The other is to raise the money to pay the lawyers to do so. Now, the need for the 3/4 vote is significant. Even if we were going on our own and we didn't need the legal resources, going to Supreme Court can, if we're unsuccessful, result in a cost action against the strata corporation. So if we brought legal action against an owner and we were unsuccessful, we could be faced with the owner's legal costs and some portion of the owner's legal costs. So it's a risky endeavor, and for that reason, I think quite appropriately so, the Act requires that 3/4 of the owners approve it. Having said that, then 3/4 of the owners are perhaps not involved in this, and they don't care, and they don't really want to incur any costs or any risks, and they're really not bothered by Mrs. Jones and her dog, so we'll just let it go. But what that does is it prevents the strata from enforcing the bylaw at all. So Mrs. Jones gets to keep her dog and ignore the fines. And then Mr. Smith comes in with his Great Dane. And then, it proceeds from there. Well, how do you enforce against Mr. Smith if you haven't enforced against Mrs. Jones? Ultimately, you have a bylaw that's simply not enforceable. So it's a problem. It's a huge problem in stratas, and owners have to either, my advice in those circumstances is go back to the owners and see if they'll approve a 3/4 vote to get rid of the bylaw. Right. Perhaps we need to amend the bylaw to make it more workable in circumstances. Life changes, people change. A no pet bylaw 10 years ago may not be appropriate now for our strata. So let's look at that and look for reasonable solutions. At the end of the day, it may just be the owners don't want to change the bylaw, but they don't want to go to the trouble of enforcing it. So it's a problem. And we saw a case a couple of years ago where we had an owner who was continually breaching the bylaw. It was, I think, front page for a few months. This is an owner and her son who regularly ignored the bylaws. There was yelling, screaming, shouting, swearing. I'm advised by the lawyer that acted for the strata that there were over 1,000 complaints in respect to that owner. Now, ultimately, that strata had to go to court. They had to go to court at least twice in order to resolve the issue. The first court application, they were able to obtain an order that the owner comply with the bylaws. Unfortunately, she chose not to, so they had to go back again.
Right.
But I mean, it's not a. It was a long, it was an expensive, and it was it's divisive in a strata to see that type of litigation go on for years, and in this case it was 3 or 4 years, and I'm told the legal fees were in excess of $300,000.
And there's no guarantee that as the strata corporation commencing a dispute, you're going to recover your legal fees. It's unlikely. You're going to bear some of the costs, so it becomes the cost of doing business as a strata corporation simply because we're enforcing a bylaw that dealt with the fact that no dogs are permitted.
Absolutely. The strata was right. The bylaw was enforceable. It said no dogs. An owner has breached the bylaw very clearly, and yet the strata is going to be forced to spend money.
Right.
Because when you do get a costs award, if you were able to do that, you're going to get costs based on the court tariff, which is not going to give you a full compensation on
Right.
a solicitor-client basis.
So Shannon, that's a pretty dynamic change when we start thinking about tribunal. When tribunal becomes mandatory, strata corporations, the strata council will be enabled to commence a complaint or an enforcement application against an owner. They won't need a 3/4 vote. It's a decision of the strata. The provisions of the act requiring 3/4 vote don't apply under the tribunal. So the strata council, but we're not also spending significant amounts of money on jurisdiction or courts. So strata council commences the complaint. The other party is invited to respond. And when this becomes mandatory, they'll be required to respond. But we also don't have the court costs. We don't have costs for legal costs that are associated with it. It's a pretty dynamic change for the public.
It is, because the barriers to accessing justice are going to be torn down through this process. And technology is one way that we can do that. We can just make it very simple for people to use this way to resolve their disputes. They don't even need to leave their home if they don't want to. But we're also making the costs quite low, and we're making the time very short. So those are all the traditional barriers for people. And for strata corporations, it will be a very efficient, quick, cost-effective way to enforce bylaws. And at the end of that process, when they have a binding tribunal order that's also enforceable as a court order, they can file that with the Land Title Office as well. And so there is another enforcement mechanism there. But overall, you're not going to be requiring the Strata Council to spend way more on enforcing the bylaw than the fines that are recoverable would even amount to, or the value of that
Right.
bylaw to the community would make it worth it.
Yeah, well, that's the irony of how disproportionate it is. You could have $500 of fines, but to enforce the bylaw, it could cost you $50,000 to $100,000 under the conventional system. That's the irony of it.
And how do you value a bylaw? What's the value of a no-dog bylaw? I mean,
Right.
these really aren't.
Yeah.
There's no monetary value to them. They're part of our living arrangement.
Well, and take strata corporations. Strata corporations struggle with the issue of whether to allow barbecues or not allow barbecues, and those that do allow them try to monitor it to specific time periods, right? So it's dinner hour, or between 5 and 8 o'clock. Somebody's decided they want to barbecue at 10 o'clock at night when people are in bed and their windows are open, and that's a bylaw violation enforcement issue. How much value do you put on that to get into a courtroom?
Is it worth it or not?
Is it worth it or not? Which is one of the struggles I think that strata corporations have. I see this providing so much relief to not only strata councils, but also strata owners who live within communities, so that there's no longer this back and forth tussle over the interpretation or the enforcement of bylaws, where there's an accessibility that's economic and timely to get some real answers.
And I think what Adrian was saying in terms of the cost and the effect on the strata community is really important. And stratas are really a microcosm of our greater society. They're neighborhoods and communities unto themselves. And if you don't have a viable way to resolve disputes that inevitably arise in those communities, what you do is really tear away at the fabric of people's lives. And this is where they spend their time, it's where they sleep, it's where they raise their families. And if you tear that apart by not allowing people to resolve their disputes in a way that's less destructive than the dispute itself, you really undermine that.
Right.
And there are so many people living in stratas nowadays, and that number is increasing. It only makes it more important that we establish those processes. They're necessary to civil society. So even though we're starting on a small scale, I think what we're doing is really, really important in terms of strengthening civil society generally, but also these strata corporations as microcosms of that society.
Is there another online tribunal system like this in the world that exists?
Not that we know of. So we know it's the first of its kind in Canada, and it's at least one of the first in the world. So we're being watched pretty closely by other jurisdictions, the United Kingdom, Australia. Later this week, I'm going to Texas to talk at a conference about it. There's a lot of interest, and it's taking root as a concept in different jurisdictions. but we're really the pioneers in BC, and that's one of the reasons why it's taking a little longer than we'd like to get the tribunal up and running. We're really starting from scratch, but we have lots of eyes watching us.
So it really is, though, in a sense, taking our justice system and putting it back into the hands of the public.
That's right, and that's really the guiding principle that we're using when we are developing every aspect of the tribunal. What would a participant want? What would a participant need? What's going to help people who have barriers to accessing justice right now? And those come in all kinds of shapes and sizes. If we're in their position, what would the justice system look like? And we're really trying to build the CRT around them, around their lives, their jobs, their families, where they live, their level of comfort with technology.
Right. I'm Tony Giovento. I'm the host of the show. Adrienne Murray, a lawyer with Hammerberg and Partners, and Shannon Salter, the chair of the Civil Resolution Tribunal, are with us in the studio tonight. We'll be right back after these messages.
There's still more ahead with Experts on Call on CL 650.